All right, let's get right into it. Today, we're going to break down one single Supreme Court case, a case that led to one of the most massive and, you better believe, controversial court orders in American history.
Just look at that number, 46,000. That's how many convicted criminals a federal court ordered the state of California to release from its prisons. It's a mind-boggling figure.
So, how does that even happen? Seriously, how can a court make a decision that big with such unbelievable real-world consequences? Well, that is the puzzle we are going to piece together today. So let's start with the order itself. The moment the highest court in the land made a decision that sent tremors through the entire justice system. The case is called Brown versus Plata. And back in 2011, in a razor-thin 5-4 decision, the Supreme Court basically said, yep, the lower court was right. California had to shrink its prison population. And not by a little, by a lot. But, a ruling like this doesn't just pop up out of thin air. To really get what's going on, we have to rewind the clock and look at the decades-long crisis that was boiling over inside California's prisons. Okay, get this. For more than 10 years, California's prisons were running at nearly 200% of their designed capacity. 200%. That's like taking a house built for 4 people and cramming 8 people inside, day after day for years. The system was just ready to snap. And what's so wild here is how this whole mess was kind of a perfect storm created by the voters themselves. First, back in '78, Proposition 13 made it incredibly hard to raise taxes, which meant no money for new prisons. Then, in 1994, the famous 3 strikes law gets passed, and boom, the prison population explodes. So you've got way more prisoners coming in, and zero money to build places to put them. By 2006, it was so bad the governor had to declare an official state of emergency. And the results of all that was a human catastrophe. The court records paint this absolutely horrifying picture. 200 prisoners crammed into a single gym, up to 54 inmates sharing one toilet. They found suicidal inmates were being held in cages the size of a telephone booth, sometimes for hours, because, and this is a direct quote from an official, they had no place to put him. Medical care was a total disaster, with sick inmates just waiting for hours in cages. The system wasn't just broken, it was actively causing needless suffering and death. And all of this brings us right to the heart of the constitutional debate. This case wasn't just about a state having crowded prisons. It was about whether those conditions violated one of the most fundamental protections in the Bill of Rights. We're talking about the 8th Amendment. Now, historically, this was understood to ban truly barbaric punishments. Things like being drawn and quartered or burned at the stake. It was designed to prevent physical torture as a form of sentencing. But this case forced a huge question. Does that protection against cruel and unusual punishment stop the second a person is sentenced? Or does it follow them into prison and actually govern the way they're treated behind bars? This question right here is what split the Supreme Court right down the middle. All right, let's look at the argument from the majority, the winning side, in an opinion written by Justice Anthony Kennedy. For him and 4 other justices, the situation in California was a flat-out, unconstitutional failure that the courts had a duty to fix. Justice Kennedy argued that the 8th Amendment isn't just some list of banned tortures. No, it's driven by a core principle, human dignity. His logic was that when the state locks someone up, it takes away their ability to care for themselves. And because of that, the state has a responsibility to provide basic care. A failure to do that is a direct assault on a person's dignity. And the evidence they reviewed showed a system in total collapse. I mean, look at these staff vacancy rates. More than half of the necessary psychiatrist positions were empty. One expert even testified that even if California magically filled every single vacant position, it still wouldn't be enough to handle the level of need created by the overcrowding. So for the majority, this was the absolute key. You couldn't fix the healthcare crisis without first fixing the population crisis. Overcrowding, they said, was the primary cause that made any other solution totally impossible. It strained the facilities, it overwhelmed the staff, and it created this chaotic, violent environment that prevented any real progress. But 4 justices furiously disagreed. They built a powerful counterargument, led by Justice Antonin Scalia. He saw this not as a necessary remedy, but as a truly dangerous abuse of judicial power. And Scalia did not mince words. He called the order a judicial travesty and maybe the most radical injunction in American history. So yeah, for the dissenting justices, this wasn't the court's job at all. Scalia's argument really centered on this key distinction. See, a traditional court order, an injunction, it's usually a simple command. Do this one thing or stop doing that one thing. But what the court issued here was something called a structural injunction, which is when the court basically takes over as the long-term manager of a huge social institution, like a school district, or in this case, the entire California prison system. It effectively turns judges into prison wardens. He argued that judges are just not qualified for that. As he wrote, 3 years of law school gives you zero insight into how to run a prison system. He saw this as 3 judges, based on their own policy ideas, making massive guesses about public safety, a job that our government gives to elected leaders, like legislators and governors, not to unelected courts.
And on a purely legal level, the dissent argued the order violated the Prison Litigation Reform Act. That law says any relief has to be narrowly drawn to fix the violation for a specific person who was wronged. But this order was this giant sweeping command that rewarded 46,000 prisoners, most of whom, Scalia pointed out, weren't even part of the sick or mentally ill groups that brought the lawsuit in the first place.
So when you pull the camera back, what we're left with are 2 completely different, deeply held ideas about what the Constitution means and what the role of a court even is. This case really goes far beyond just prisons. This table sums up the clash perfectly. For Kennedy and the majority, the 8th Amendment is a broad shield for human dignity, and that means courts have to step in when it's being violated. And the only solution here was to reduce the prison population. For Scalia and the dissent, the 8th Amendment is a specific ban on torture, and courts go way too far when they try to become managers. For them, this order was a radical overreach, just judges making policy from the bench. And all of this leaves us with the huge, enduring question of the very heart of Brown v. Plata. It's a question about where the line is. When the political branches of government, the legislature, the governor, when they are unable or maybe just unwilling to fix a crisis that violates people's fundamental rights, what is the proper role for our courts? Are they supposed to be the last line of defense? Or are they becoming unelected policymakers running wild? This case doesn't give us an easy answer, but it forces every one of us to confront the question.